We're on the record 05-2024 DR 52505. This is the matter of Thomas Hudson and Shauntel Hudson. We have scheduled for today and the petitioner's emergency motion for contempt and enforcement was filed on behalf of Mr. Hudson. I noticed that we have a notice of appearance for today. Sir, if you please announce your presence for the record.
Yes, Your Honor. My name is Pete Malinelli. I'm here on behalf of petitioner Mr. Hudson. Scott Smith, or his associate, Adam Holbrook, is here as well. He just stepped outside for a moment. He'll be here as well, but I'll be presenting anyway.
Okay, thank you. Ma'am?
Good afternoon. My name is Linnea Anderson, and I represent the respondent, Shauntel.
Thank you. Okay, and Mr. Molinelli, how do you wish to proceed, sir?
Yes, Your Honor. I can make some brief opening remarks and then proceed from there.
Yes, sir.
Please, the court. Your Honor, we are here on behalf of Thomas Hudson to seek a motion to contempt and enforcement of a parenting plan that was agreed to back in April of 2024. But to understand the circumstances and the basis for the motion to contempt, we actually have to go back a little bit before that. Your Honor, Mr. Hudson was married to Mrs. Kepner now for almost 15 years. They got divorced in 2022. There was a parenting place that was put in place from 2022 all the way through. In January of 2024, that is when Mrs. Hudson, Ms. Kepner, the respondent in this case, started being involved in a relationship with Christopher Kepner. At that time, the respondent and the petitioner were living in Hernando County, Florida. From the time of the divorce and the agreed parenting plan for 2022 to 2024, Mr. Hudson received regular and normal visitation with 3 children, AH, TH, and BH. With no issues whatsoever, no problems with the parenting plan, no issues with visitation whatsoever, no therapy, nothing like that. Things started to change in January of 2024, and that's really the operative date. That's when the respondent started pursuing a relationship with Christopher Kepner. During that time, they were just simply girlfriend and boyfriend. As I said, they were both residing in Hernando County. A couple months into that relationship, the respondent went ahead and asked Mr. Hudson if she could move to Titusville. Obviously, Titusville being in Brevard County was not in accordance with the parenting plan, and they required an amendment. And Mr. Hudson was reluctant to give this agreement. However, the respondent assured Mr. Hudson that the reason why she wanted to move to Titusville, Brevard County, was to pursue a better financial opportunity for herself, as well as to pursue improved schooling for the children. Reluctantly, the petition in this case agreed. An agreed parenting plan was made. It was filed as an exhibit to our trial exhibit list, which we'll obviously talk about during the testimony in this case. In that agreed parenting plan, it specifically stated that the parenting plan was to be reviewed on June 1st every year going forward to determine A, if the respondent had in fact procured better financial opportunities, and B, the progress of the children. As we move fast forward, you'll see why that becomes relevant. Several months into 2024, there came a time when it was agreed and signed that the respondent was going to take the 2 minor children at the time, in this case TH and BH, with her to Titusville. There was a child, AH, who you'll hear from today, who was 17 years old and at the time was a junior in high school in Hernando County. Because of that, it was agreed upon between both the petitioner and the respondent that AH would stay with the petitioner until he finished his junior year in high school, after which time they would possibly seek relocation of AH as well to Brevard County. Here's where things kind of get interesting. So somewhere in early of 2024, the respondent in this case did in fact move to Titusville with Christopher Kepner, her still boyfriend at the time. Mind you, this relationship has only been a couple of months strong, but regardless, she made the decision, and her 2 children did there. What's important to note is that during that time, between early April of 2024 and April 22nd, 2024, this is going to become a very important date this whole matter. Thomas, the petitioner in this case, did in fact ask for and did receive visitation with his children overnight, even though at that point the respondent was already residing in Titusville. In other words, they made arrangements, they had this agreed parenting plan, there was a pickup, there was an overnight visit. I would like to mention that there's absolutely no evidence that there has been any issue with any visitation of the children wanting or not wanting to go before April 22nd, 2024. There's just simply no record evidence. It wasn't until the date of April 22nd, 2024 that things began to change. On April 22nd, 2024, and the court is going to hear testimony to this effect, at that point, the AH was at high school in Hernando County. Unbeknownst to the petitioner, received no prior notification, no prior notice. And that particular day, the respondent and her then boyfriend, Christopher Kepner, drove to the high school and then picked Andrew A.H. up against his will. Andrew had told the respondent several days before that he no longer wanted to go with her to Brevard County. His high school was here, all his friends were here, this is where he wanted to stay. At that point, the respondent did not like that particular answer, so she took it upon herself, again, never communicating with the petitioner in this case, drove to the high school, and forcibly removed A.H. from the high school, putting them in Christopher Kepner's vehicle. At that time, the only way that the petitioner was even informed that this was going on was because the school called the petitioner to let him know what was happening. Interestingly enough, when they took A.H. and they put him in the vehicle, they took A.H.'s phone, and that being the respondent, as well as Christopher Kepner, shut off all location, so he could not be tracked by the petitioner in this case. Things get even more interesting. They go ahead during that visit. There's a struggle in the vehicle, in which case A.H., and you're going to hear testimony from A.H. today about all this, was in the vehicle, and he wanted to get out. He did not want to go with the respondent to Titusville. They physically restrained him, and he was assaulted both by the respondent and by Christopher Kepner. There are pictures and photographs that we have introduced and put in an exhibit that we will again introduce through A.H. in this case that evidences the restraint that happened. A.H. will testify about the restraint that happened by Mr. Kepner and by Shauntel. Basically, they held him in the back of the seat. Christopher Kepner reached back, and his head pinned against the back of the armrest, or one of the headrests, and there's photographs to show that damage. They eventually made their way to Titusville, to Brevard County, at which point the petitioner in this case went and drove to the respondent's address. They went there, authorities were called, DCF was called. Obviously, this created quite a bit of a stir for everyone involved. Ultimately, it was determined, because A.H. had said so, A.H. being 17 years old at the time, told law enforcement authorities, as well as DCF, that he did not want to go with the respondent, that he wanted to go back home with the petitioner in this case. And that's what happened. And the petitioner has A.H. has resided with the petitioner since April 22nd of 2024. He's have not since returned to see the respondent. As we fast forward a little bit, it's going to be our position, Your Honor, that event that the respondent in this case is characterized as a kidnapping, which is actually the actual opposite of what happened. It was the respondent and Christopher Kepner that went ahead and took Andrew A.H. against his will. The respondent in this case, and this is what is the basis for the motion for death, used that kidnapping as a way to set up this systematic and alienation of both T.H. and B.H. for over a year and a half. The petitioner in this case, except for 2 weeks ago, has not had any overnight visitation with his children, B.H. or T.H., since that incident happened. After the incident on April 22nd, the respondent then went ahead and took both B.H. and T.H. to a therapist, told the therapist that the children were afraid of being kidnapped by their father. Mind you, there has never been any issue with either child saying they didn't want to go with the father up before April 22nd, never any issue with visitation, never any allegations, there's none of that. It's not until this April 22nd incident where the respondent was denied access to A.H. because of A.H. choosing to be with the father, this whole thing set this chain of events in play. So the respondent goes ahead and takes T.H. and B.H. to therapy in early May The respondent in this case actually tells the therapist that the children are afraid of being kidnapped by their father and not being returned home. Also in those notes, which we have a copy, they're redacted, obviously some of them are a little sensitive, but there are in those notes references in which the respondent's case alleged that the petitioner in this case engaged in physical abuse, verbal abuse, both for all three children and against her, both during the marriage and after. There's simply no evidence of that whatsoever, Your Honor. That was simply made up by the respondent in this case to again start this chain of events to alienate both TH and BH against their father, the petitioner's case, Thomas Hudson. From there, Your Honor, there's a course of therapy that takes place, and we have a chain of, it's a bit of a slop, I'm afraid to say, emails and text messages that go back and forth regarding the whole visitation issue. There's some critical emails that are centered around April and June of 2024. April 24th of 2024, in this particular case, the petitioner's case specifically asked the respondent when he was going to get his visitation pursuant to the agreed parenting plan that was signed in April of 2024. In which case, the respondent never responded to that. He followed up 2 days later on April 26th about his visitation, both with TH and with BH. And at that point, on June 5th, the respondent actually wrote in an email saying that he was not going to get visitation at all because of what the children were saying and how now they're afraid of him and they don't want to go with him, and kind of set this whole course of events. I have the emails to establish that. From that time forward, Your Honor, up until literally 2 weeks ago, he has had no visitation with his children, strictly against the parenting plan that was entered into on April 2024. Interestingly enough, in the email traffic and the notes, the therapy notes, somewhere around August of 2024, there's also another note from BH where she's indicating, she's not afraid of her father, but that she wants these very specific parameters. Quite frankly, this disingenuous coming from an 8-year-old about how she would be welcome to visitation as long as it's in Bard County in a public space, with the stepfather there, something to that effect. Which obviously shows, in our mind, a certain degree of manipulation that's going on here in this concerted effort to keep Thomas Hudson from the children. I will also tell you that during that Titusville incident, there's going to be testimony to this effect that Mr. Kepner informed when they were at Titusville that he was not going to get to see his children again absent court order. That was relayed to him at the Titusville when the police arrived and when DCF was there as well. So we have this path now where the respondent is with her boyfriend. She's obviously upset about what happened with Andrew Hudson. There was an injunction that was filed, just so the court knows, in Hernando County regarding this injunction. There were some findings there. I will tell the court that those findings are obviously, it's a different type of hearing than we are today. It's a different evidentiary basis for that. In that case, they declined to pursue any type of charges against Christopher Kepner. I will tell you, and this will probably come out either through the cross with Christopher Kepner or otherwise, obviously Mr. Kepner denies having any type of assault. So in essence, the court just said, well, that he said, she said, I don't find enough here, and that's why it happened with the injunction. We're not offering that purposes for establishing and proving assault by Mr. Kepner, although we do think that's what happened. What we're offering is this intent element. And as the court is well aware, when you're dealing with issues of custody and time sharing, and you file a motion to contempt, quite often there's an argument that one parent says the child didn't want to go, right? And we all know, and the case law is very clear on this, that is not enough. Obviously, the custodial parent has the obligation to try to do the best they can to encourage and allow that visitation to take place. And you can't just simply say, okay, well, the child didn't want to go, so you don't want to go. There's case law on this, but whether or not that rises to the level of contempt, right? And it's kind of all over the place a little bit, Your Honor. We are aware of some second DCA cases out there that talk about this particular issue. But really what we have is, okay, we definitely have an issue here where I expect the respondent to argue, well, the children didn't want to go, and the therapist said they didn't want to go. I can tell you the therapist in the therapy notes, I saw no notation where the therapist said they couldn't go. What you do see is some parroting that's coming from the respondent through the children to the therapist.
I'm going to object, Your Honor. He's offering testimony of what he believes he's offering testimony from counseling records. There's been no 12.363 order to allow the counselor to testify or for the counselor's notes to come in. So I don't know why we're talking about them. They're not admitted, and my understanding is they can't be admitted under these circumstances.
I will let you know that when I'm listening to opening statements, I don't take it as evidence. take anything he's telling me as evidence.
Thank you. Anyway, these therapy notes, obviously, we can deal with that issue when we get to it. The kids do go to therapy for several months, and as time kind of goes on. So then what happens is, so Thomas, the petitioner in this case, does not receive any visitation. There are numerous emails to the respondent, him saying, hey, when am I going to see the kids? When can I see the kids? Tell the kids that I love them, all of this type of stuff. The respondent always responds, you know, the kids aren't ready to see you, they don't want to see you, you know, that's not going to happen, and I'm worrying about their emotional state. In other words, that in this case, this is what the case law is important for, is that, okay, if you just have the child saying, I don't want to go, that's one thing, but you need some act by the custodial parent that helps facilitate it. And that's really what we have here. You know? That's why this April 22nd thing is so important, because what that does, using the plaintiff, the respondent's own words, characterizing this as a kidnapping, when there was no issue with visitation before April 22nd, is a direct attempt to go ahead and poison and alienate the children, the young children, the 8-year-old, and I believe a 12-year-old at the time, against their father. And that's basically what happened, to a large degree. She got what she wanted. There was some hesitation by the children at that point to see their father, despite the father's repeated attempts to do that. The father, and there's a testimony from the father that he went ahead and went to the reported pickup site. The respondent would not show. They would say the kids got sick or create some excuse for that. And always falling back on, hey, we're not going to go until the children say it's okay to go. And the case law is clear on this as well, Your Honor. An 8-year-old child does not get to decide that. That may be a factor that the court consider, but there on its face cannot just display, I don't want to go with dad, therefore we're not going to have visitation. Just think of the nightmare that would create for the court system. Nor can you simply go to a therapist and use that as a conduit to get that exact same testimony out. It's not enough. So going back to the case law on it, you need to show a couple of things. You need to have intent, right? You have to show some act on the mother. Our act on the mother is we have this kidnapping incident, again, where it was AH that was actually kidnapped, if we're going to use that term, against her will, and set this kind of bad motive in place. So it's the mother's actions that's now influencing and controlling both the 8-year-old and the 12-year-old at the time. So as we continue forward, Your Honor, eventually November 4th of 2004, the petition in this case ultimately went ahead and filed this emergency motion for contempt and a petition for modification to the parenting plan, because obviously the parenting plan was not working. In that instance, despite the best efforts, for whatever reason, there was not a hearing that was granted until now. So almost 13 months later, a hearing was granted. And here's where we are today. And during that time, from the time that that motion was filed until the current day, except for 2 weeks ago, there has been no visitation, overnight visitation allowed by the respondent to petition, to show this ongoing. And there's some case law that talks about if it's the first day, like the first time parents are divorced, and there's a parenting plan, and kids are kind of upset, there's one thing, right? This was not the first day that these children were dealing with divorced parents. It was not the first day that they were dealing with visitation. I think that's an important distinction, especially when you look at the fact that from April of 2024, the beginning of April, before that, there were no issues with visitation. There was no child ever said, oh, I don't want to go with my father. There was no allegations of abuse. There was no allegations of physical or verbal abuse or anything like that. It wasn't until this incident that everything went ahead and changed. So we have the intent of the mother now changing, and now the actions of the mother now changing. And despite no wrongdoing on behalf of the petitioner, he has not had visitation. But here's where the story gets even more interesting, and why we have so many courtroom cameras in this courtroom even right now. There was this continued effort for the petitioner to see his children. That there's plenty of email traffic and text messages that sort through where he's trying to establish and reconnect with his children during the time period of January of 2025 up until the present time. What happens during the May-ish time frame, 2025, the respondent in this case goes ahead and tells the petitioner that she would like to take the children on a cruise. In which case, it is related to this, on a cruise, right? And then in which case...
Your Honor, I'm going to object. You just sent an email to counsel yesterday indicating that you were only hearing...
I did. Two things, Mr. Molinelli. One, I will not hear anything that has to do with that second motion. I did send an email about that. That's number one. For two, I will remind you both, we have 1 hour.
Yes, ma'am.
We've been 15 minutes.
Yes, ma'am.
Actually more than 15 because I started splitting, right? And okay.
The only issue about the cruise is consent issue. There's nothing, we're not talking about anything else that was alleged in the prior motion. It's just that the petitioner in this case did not consent, and this goes basically to the respondent's ongoing attempts to basically thwart the petitioner in this case's parental role in this case. That's all I want to talk about, is that there was no consent. That's it. Nothing about anything else. I understand what the court said. I saw the email. I do appreciate it. In any event, so there was a hearing that resulted from that. The first time that the petitioner was able to get overnight visitation, well, there's a Thanksgiving, so there was a Thanksgiving day in which the petitioner had a perfectly fine Thanksgiving with the one child BH. They went over to his residence in Hernando County. They spent the day. The exchanges went fine. The drop-off went fine. The pickup went fine. Everything went fine. Dropped the child off. There was no big commotion about any of that. The hearing takes place on the 5th. Later that afternoon, they had visitation. Again, that's his first overnight visitation. His first overnight visitation on December 5th, 2025, from April of 2024. In that case, BH goes to the designated drop-off point. They drop the child off. The child does go with the petitioner in this case for the overnight visitation. We're going to have testimony from Mr. Hudson about that, about what happened during that visit. It was a perfectly fine visit. You'll have testimony from age as well too. Andrew Hudson, who's 18 years old now, about that particular visit. There's photographs that we submitted as an exhibit to show that that visit went without a hitch. Brooke BH actually stated to her father that she wanted to stay another night, just to show that it's in the best interest of the child for both the petitioner and BH to be reunited so that they can go ahead and foster and re-foster that bond that they had, which was very, very strong before this incident happened. Based on that, Your Honor, we think, and we're going to hear the testimony in this case, that cumulatively what that demonstrates is the response in this case, willful determination to thwart the parenting plan, and is the basis for a motion to contempt. Also in contravention to Section 61 that deals with time sharing activity. Because of that, Your Honor, we're going to ask for 140 days of makeup time. We're going to establish that, and we'll get that through Mr. Hudson about how we came to that figure, as well as an enforcement from this court saying, hey, we need to follow this enforcement plan regardless if the child says they don't want to go or not. We need to have a plan in place to deal with that, as well as attorney fees and costs. Your Honor, I appreciate your indulgence. I know I went a little bit long, and we will get to the testimony in this case, but thank you very much.
Citizen?
Thank you, Your Honor. Briefly, the respondent and petitioner entered into an amended parenting plan back on March 12, 2024 to allow her to relocate with all 3 children of the marriage to Brevard County. The agreement is very clear. It's in writing. There's nothing ambiguous about it. Both parties signed it. As a matter of fact, both parties drafted it themselves and read it and signed it and submitted it to the court. And then the court entered an order ratifying that and ordering the parties to comply with that agreement. Yes, Ms. Hudson, now Mrs. Kepner, was in fact divorced. She started dating Mr. Kepner back in October of 2023. There were issues with the children even at that time. They tried to say that prior to that, to her wanting to move over there, that everything was ideal. It was not. The children had been in counseling since December of 2023. So even before the move to Brevard County was contemplated by the parties. I should also note that on this agreement that they signed, which is an amended parenting plan, it says very clearly in the amended parenting plan that any modifications to this parenting plan shall be in writing and signed by the parties. They want to come in here and tell you that my client is in contempt because she removed the child, the eldest child, from school in Hernando County and moved him to Brevard County. She didn't violate anything. That's what the paperwork says. It's in plain English. Everybody can read, and they understood it. He signed it, but now they want to come in and say that somehow she's in contempt for wanting to take the 3 children, which is what the agreement says. So I do think that is a problem. And then he's trying to say that there was no tracking. He had location tracking device on the child, so he knew where the child was. He arrived at the respondent's residence and started screaming and yelling to the other 2 minor children to get their ass out there to come and see him. He was very vulgar and rude with them. And so there was a natural fear that these children had about going there. And during the time, it should be noted, they filed this an emergency motion. They call it an emergency motion for contempt that they filed on November 4th of 2024. It was denied as an emergency and told to be set on the court's regular calendar. They never set it for hearing until October of this year, over almost a year later, for a hearing date for December, which is today, December 17th. So if it was such an emergency that you had to ask the court to give you emergency hearing time, why don't you wait a year to set it for hearing? The reason why they wanted to wait a year to set it for hearing, Your Honor, is because when he took the oldest child, he came down to Brevard County and took the oldest child on that April 22nd day, brought him back. He never allowed the mother to have contact with the eldest child, claiming that the child didn't want to see her. So he's in violation of the very agreement that he's accusing mom of being in violation. And under the clean hands doctrine, you can't ask to hold somebody in contempt of an order that they're not themselves in compliance with. But the eldest child turned 18 in October of this year. And so thereafter, that's when he set this hearing for December, interestingly. The children have been in counseling the entire time that is the time frame crafted in the motion, which is basically from March of 2024 up through November of 2024. The children have been in counseling, so these issues were discussed. And as a matter of fact, with all the emails and notes that opposing counsel mentioned, there's emails asking the father to participate with counseling with these two younger children. There was no counseling that mother was asked to participate with regard to the eldest child. And he said the child was in counseling, wouldn't even tell the child or tell the mother what the full name of the counselor was. So the mother couldn't even call to get that information. But having said that, he's had this opportunity to participate in counseling. And there were weekends where he asked for time sharing, which mother complied with. On some of the weekends, they were her weekends. She even offered and invited him to Thanksgiving last year. And they're putting in their motion that he didn't get Thanksgiving. Well, if you read the agreement, again, the one they signed together in March, it says that in even years, which would have been 2024, she gets Thanksgiving. It's not even his Thanksgiving. So I don't think she can be in contempt of something that, again, she wasn't in violation of to begin with. It doesn't comport with what's in the agreement. And the last thing, and I know we're not here to talk about the unfortunate cruise, but when he's saying he's just doing it for consent purposes, if you read, the same amended parenting plan that they signed, it clearly says she doesn't need his consent. She's required to give 60 days notice that she's going to take the children out of the country, which she did comport with. So, again, she did what she was supposed to do and acted at all times in accordance with the parenting plan. There were many weekends where the father didn't even, it was his weekend or every other weekend time sharing, didn't even ask, didn't confirm. One time he didn't even show up for the time sharing. My clients went to the meeting place, didn't even show up. So again, I don't see how this client can be found in contempt. Furthermore, the Florida law provides that even if you were to find that there was any contemptuous behavior, changing custody is not the answer to it. In fact, the case law supports that you can't change custody as a basis for that. And it also depends on what's the best interest of the children. If the court doesn't find that it would have been in the best interest of the children to do that at that time, then certainly there could be no contempt as well. And thank you.
Sir, you want to call your first witness?
Yes, Your Honor, we would like to call Andrew Hudson.